Mr. Chairman and members of the Judiciary, I'd like to first say I gave my experience out to the clerk to show what my past has been with my careers, as well as the Michigan State Police, teaching in public education, and so forth. And also my experience with criminal civil asset forfeiture. I did find that talking to some of the drug teams, that some of the drug teams were basically unloading houses on search warrants for drugs, and this was before medical marijuana, so this was all drugs were illegal at this time. And they basically emptied houses out. And basically, if they needed a couch for their office, they would take a couch. If they thought it could generate some revenue, they'd take that. And them and the prosecutor would make a deal with the criminal case and would negotiate the property and the criminal case. In my opinion, at that particular time, and I still hold that opinion, that was not what the forfeiture law was intended to do. There was a lot of issues when it came to medical marijuana, as you all know. So how did this affect criminal civil asset forfeiture? Some cities allowed dispensaries, even though there was nothing in the state law to allow dispensaries, but cities allowed them. The police would come in and raid them and take their assets. I believe that the policy and procedures of CAF erodes the trust and is perceived to incentivize law enforcement.
With me are two clients of mine that I've represented in court proceedings. Both I would describe as being victims of both the Michigan Medical Marijuana Act bad interpretations and also forfeiture law. And we've submitted for review, I have like an index of various events that have taken place in some cases that I think evidence or should hopefully convince you that there are some real problems with the existing forfeiture law. Like the Michigan Medical Marijuana Act, there's this concept of immunity, and in forfeiture there's this concept of constitutionally protected property. And what unfortunately happens is both the person's immunity and their right to property is determined at the time by the police without any kind of due process. The reason why these individuals are here is really to emphasize the point that they are people that were charged with crimes and utilized the Michigan Medical Marijuana Act to defend and or have the charges dismissed. And independent of that, they still were victims of forfeiture. Mr. Fisher defended himself under Section 8 of the Michigan Medical Marijuana in Isabella County. There was a forfeiture proceeding that had been stayed pending the outcome of the criminal case. The criminal case resulted in a dismissal of all charges. The MMA says if you prevail under Section 8, there shall be no forfeiture. And when we went to try to get the property returned, the prosecutor's office filed a motion to recuse the judge. Recuse the judge because 17 years ago, the judge made a negative comment about forfeiture. Things are getting strange, and things are very unusual amongst government officials in this arena. I don't know of any other government agencies that are given a budget and then go out and earn money on top of that and use the money for their own purposes, and that is the system that's been set up.
My name's Amanda Jocelyn. I'm a caregiver, I'm a patient, I'm a mother, daughter, neighbor, and a friend. I'm a law-abiding citizen, and I'm also a victim of policing by profit. Interestingly, many of which, not only myself, in many cases, these folks are never charged with a crime. However, all of their things that they've worked for so many years are just gone. And imagine, if you will, having a complete stranger go and rifle through your closet, your drawers, every little private nook in your home, and just throw it all over the place and then pick and choose what they'd like to take home with them. They took even a steam mop. And all of this was based on an illegal search warrant.
I'm also a victim of civil asset forfeiture as of April of 2016. I'm 51 years old, and my name is Steve Fisher. Prosecutors vigorously fight to try and keep my property, even after a dismissal, is quite disturbing to me. Back when this happened, we also had to pay the bond that they were allowed to put on the property at the time, just so we could have our day in court to fight to get our property back.
You wouldn't see an increase in arrests of marijuana 14% every year and 15 million in proceeds when you have a state law that was intended to stop that behavior. Statistics show it, because you got an increase in funds and an increase in arrests. These things that I'm talking about have been used, unfortunately, to promulgate and increase the forfeiture proceeds.
My name's Steve Miller. I have just almost 25 years law enforcement experience. Started with the United States Air Force Security Police right out of high school. Did a tour in Desert Storm in Saudi Arabia. Moved on to the Milan Police Department as a patrol officer for a couple of years. Went to Canton, worked in patrol, detective, promoted to sergeant, was part of the SWAT team, retired there a few years ago as a sergeant. As a prior law enforcement officer, I took great pride in my work, in my criminal cases, in the work that I submitted to a prosecutor or a court as a patrolman, as a detective, as a sergeant. I took great pride in my work, and when I submitted something to the prosecutor or the courts, I submitted that with the intent on getting a conviction. I was confident in my cases. Why do we not hold them to a higher standard in cases of civil asset forfeiture as we do in the criminal cases? So I don't understand why law enforcement should have any objections to a conviction being required in order to seize a person's property. There should absolutely be a conviction required before we can take people's property from them.